take away the private property for public purposes for the greater good of the society in a whole compared to the individual's rights. So eminent domain is what is used in India. The phrase is not eminent domain, rather it is known as compulsory acquisition. Instead of eminent domain, compulsory acquisition is used. So what happens is there have been acts which have been passed in India, with regard to land acquisition, which is the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013. So whether this should apply to traditional lands also is
a very good evening, Kumar all. Let me first state that I outright reject the idea of eminent domain applying to override the interests of indigenous people. Firstly, let me tell you the difference between eminent domain and how it is applied in India. Whereas in eminent domain, you just have to state public use. Whereas in India, you have to state that there is considerable probability of serving public interest. Let's also talk about why this came into India in the first place, which is to further the socialist principles of the directive principles of state policy.
Just turn yours on. Turn yours off.
State policy are give cause for the establishment of a socialist state of removing all disparities in income and establishing an egalitarian society. This is the reason why articles were even brought, why the directive principles of state policy even exists, and the fact that in a judgment we have clearly said that fundamental principles cannot be overridden just by placing the directive principles of state policy in a state of urgency and of utmost importance over it. What do I bring to the table? I bring to the table the problem of curtailing economic means is the best way to curtail the prevalence of a culture. Why is it a problem? It's a problem because when you take away the economic means of establishment of indigenous people, you take away their means to express themselves. That is the only place that they have to show for their identity. That is the only place that is reminiscent of their culture, given the fact that people who colonize it, who build colonies,
can vote. Earlier there were discrimination between men holding property and then women who are paying tax, poll tax, a lot of things. That is why I would say that the courts have always been an instrument in reversing the anti-discriminatory laws. For example, we also know about the Brown vs. Board of Education, Plessy vs. Ferguson, where there has been a lot of notions like separate but equal, and so many notions has been created. Why I say this? It not deals with only discrimination based on religion. The court is as an institution deals with the most controversial issue relating to discriminatory religious practice. There are various factors involved, including age, not just the gender. It does not prohibit based only on gender. It discriminates based on age as well. So age, gender, and a lot of customs. So a lot of things are intertwined with the religious practice, and no other fora, even though as it may be like endowments and a lot of institutions, they may be specialized in one aspect, say religion or just gender studies, but a court is an institution which looks into all the aspects, which has been dealing with cases of one dispute, dealing with all the dimensions.
So what I think the problem that is addressed by the motion here is if courts and not the legislature is the right forum for two questions here. One, is it court or the legislature? Another question is, should the court or the legislature, or by extension maybe the government itself, bother itself with the religious practices of the population? So going to the first point, I would like to defend this motion, although I believe that the best way for this to come forward is through the legislature. There are certain matters that will not come up in the legislature because of certain logistical problems, maybe because of representation, because of all those little nitty-gritties. So when a case reaches the court, such a case on gender discrimination or especially relating to religious practices reaches the court, it gives an opportunity for a constitutional response to this perceived inequality. So when this kind of case comes to court, it is important for the court to take a clear-cut stance that is constitutional and guaranteed and does not compromise on any provisions provided for the constitution for all the stakeholders involved. And I will take the case of Sabarimala for example. This did not come through the legislature. It was not raised as, even if it was raised, it did not come through as a change through the legislature. It came through the Supreme Court verdict. And this was vehemently opposed, yes. But then I firmly believe that it was a necessary change.
Subscribe to Walgan Television. Please subscribe Walgan Television.